Welcome to the deep dive. If you're even remotely thinking about selling your property, well, there's one document you absolutely need to get your head around: the exclusive right to sell listing agreement.
Mm.
Think of this as unlocking the secrets to a smooth sale. It could potentially save you serious time, money, and frankly, a whole lot of stress.
That's absolutely right. We've really immersed ourselves in the details. We've got our All Notes 4162025, which includes a pretty helpful study guide,
Yeah.
and importantly, the actual exclusive authorization and right to sell, exchange, or lease brokerage listing agreement. This one's from the Greater Las Vegas Association of Realtors.
Okay, so our goal today is pretty simple. We're going to break down the must-know parts of this agreement
Yep.
so that you, our listener, feel completely informed and, confident when you see this document. Okay, let's dive right in.
Let's go.
At its core is this idea, the exclusive right to sell. What does that practically mean for someone selling their house?
Okay, so essentially, for a specific time frame, they call it the listing term, right? It has clear start and end dates, usually right there in Section 1.
Okay.
You're giving one name broker the exclusive right to sell your property. Now, the crucial insight here, I think, is that you're paying for a time commitment from the broker,
Okay.
not just like a successful sale by them.
Right.
So even if you, the seller, you go out and find the buyer yourself during that term, guess what?
The commission's still due.
The commission is still due to the broker. That's the real power of that exclusivity.
Irrevocable, right? That phrase really jumps out. Sounds like something a seller should really pay attention to.
Absolutely. And the document itself points this out very clearly. It says, this is a legally binding contract.
Hmm.
It even advises, seek legal or tax advice. If anything gives you pause, definitely something to keep in mind.
Makes perfect sense. Okay, so before we even get to finding a buyer, we need to sort of lay the groundwork. That's where the terms of sale come in, right? Section 2.
Correct. Section 2 gets into some really fundamental details. First, the listing price.
The asking price.
Exactly, the number you're putting out there. Then there's usually a suggested amount of an earnest money deposit, or EMD.
Okay, the good faith deposit?
Think of it that way, yeah.
Yeah.
The buyer's initial good faith deposit shows they're serious.
And buyers can come with different ways of paying, right? It's not always just cash.
Oh, definitely not. The agreement lists various potential financing options. You've got good old cash,
Right.
conventional loans, FHA, VA loans,
Mhm.
and even things like lease, maybe lease option.
Uh-huh.
Or if you, as the owner, are willing to finance part of it yourself, owner will carry.
Okay.
And there's usually a spot for other too, for less common situations.
Now, here's a part that sounds really strategic. The seller's choice about whether or not to disclose other offers. How does that work?
Yes. This is a key decision you make right at the start, also in Section 2. You get to decide. Will you allow your broker to tell potential buyers that there are other offers on the table? But it goes further. You can also choose whether to let them reveal the actual price and terms of those competing offers.
Oh, wow.
Yeah, this can really influence how other buyers might respond.
Huh.
Creates urgency, maybe pushes bids up, or not. It's a strategy call.
Interesting. Very interesting. So let's talk about the physical property itself. When we agree on a listing price, what exactly is included in that price?
Right. Section 3 clarifies this. Generally, the listing price covers, well, the land itself,
Uh-huh.
any buildings or landscaping.
Uh-huh.
Those are the improvements.
Okay.
And pretty much anything permanently attached or installed. We're talking about fixtures like built-in ovens, ceiling fans, maybe that fancy chandelier in the dining room.
Okay, but what about things that aren't, like, screwed into the wall? Like the refrigerator or
Right.
the washer and dryer?
Great question. That's where Sections 3A and 3B become really important.
Yeah.
Section 3A is where you specifically list any personal property that will be included in the sale.
Got
Maybe you are including that like new washing machine or some patio furniture. These items are usually transferred with a separate document, a bill of sale.
Okay.
Then in Section 3B, you do the opposite. You list any personal property that you are specifically excluding from the sale.
Like a family heirloom light fixture.
Exactly. Or maybe that specific fridge you really love. Being crystal clear here, up front, can prevent a lot of arguments and headaches later on.
Yeah, I can see that. And with all the smart gadgets in homes these days, what about smart technology?
Yes. The agreement has a specific mention of smart technology. Things like smart thermostats, security cameras, maybe voice-activated lighting systems.
Right.
If your property has these, there's likely a separate smart home disclosure you'll need to complete. It details exactly which items are staying. And remember, the general rule is anything attached stays, unless you specifically say otherwise.
What about solar panels? They're becoming pretty common sitting up there on roofs.
Good point. If your property has a solar power system, Section 3 points out that a separate solar addendum should be part of the agreement.
Okay.
This will spell out all the details of the system, like, crucially, whether you own it outright or if it's leased. That's a big one.
So even though we list all these things excluded in the listing agreement, the final purchase agreement is what really matters in the end.
Exactly. Section 3 emphasizes that the purchase agreement takes precedence. So even if you list something as excluded here in the listing agreement, if it's not addressed again in your counteroffer to a buyer, it could still accidentally end up being part of the deal.
Oh.
Sellers really need to be proactive about confirming exclusions during those negotiation stages. Double-check everything.
Good tip. And what if there are things on the property that aren't actually owned by the seller, like a rented water softener or something?
Right. Section 3E covers leased or licensed items. Things like alarm systems you pay monthly for, maybe propane tanks you rent, or, water softeners with a lien against them. You're obligated to disclose these in this section. And, crucially, you need to provide copies of any lease agreements or related documents as part of the whole purchase process. Transparency.
Okay, so we've got a handle on what's being sold, more or less. Now, how do we make sure the buyer gets clear ownership? That's where title insurance comes in, right? Section 4.
Precisely. Section 4 is pretty straightforward, actually. You, as the seller, agree to provide the buyer with an owner's title insurance policy for the amount of the sale price.
And that just protects the buyer.
It protects the buyer if there are any unexpected issues with a legal title to the property popping up later. Loopholm claims, things like that.
Okay. Now, for the part everyone always seems to focus on, how does the broker actually get paid? Let's talk about their compensation, the commission.
All right, Section 5. This dives right into the details of compensation to broker, or commission. And the very first thing it highlights right there in bold letters. Compensation commissions are not set by law or by any realtor association. They are fully negotiable.
Fully negotiable. That's huge. So that percentage or fixed amount isn't set in stone. You can actually discuss that number.
Absolutely. You and the broker will agree on a specific percentage of the final sale price, or maybe a fixed dollar amount, that you will pay to the listing broker upon the successful closing of the property.
Just the listing broker.
Yes. Keep in mind, this commission, as the agreement states, is specifically for the listing broker's work for you, the seller. How the buyer's broker gets paid is typically a separate arrangement, often detailed in the actual purchase agreement itself.
Got it. So when exactly does this commission get paid? It's not just strictly when the sale closes, is it? There are other scenarios.
Well, Section 5 outlines several situations where the commission is due. Obviously, the main one, if the property sells or is leased during that listing term, no matter who finds the buyer, that commission is paid. It's also due if you, the seller, take actions during the listing period that, make the property unmarketable without the broker's okay.
Like if you suddenly decided to stop all showings or something?
Exactly. If you actively prevent the sale from happening.
Okay.
Also, there's usually a period after the agreement ends where the broker is still protected. It's called a safety or protection clause.
How does that work?
If your property is sold, conveyed, or transferred within a specific time frame, there's a blank space in the form that needs to be filled in, usually like 90 or 180 days.
Okay.
To someone the broker negotiated with or showed the property to before the agreement ended, the commission is still owed.
Ah, interesting.
Unless, and this is important, unless you've signed a new exclusive listing agreement with a different broker after the first one expired, then the protection period usually doesn't apply.
What if there's a property exchange involved, not just a straight sale?
Good question. In an exchange, Section 5 allows the broker to represent multiple parties involved, as long as they provide full disclosure to all parties. And in that case, the broker can receive compensation from these different parties involved in the exchange.
And what happens if the whole deal just falls apart? Who pays the broker then? Does anyone?
Well, if the sale doesn't close because you, the seller, default on the purchase agreement, or maybe you refuse a full price offer that matches all the listing terms, the broker is still entitled to pursue their commission. Now, if the buyer defaults, the broker only gets their commission if and when you, the seller, actually recover damages from that buyer. And even then, the broker's share is usually capped at the agreed-upon commission amount minus certain expenses.
Okay. There's also a mention of an irrevocable assignment of funds in escrow. What's that about? Sounds
Yeah.
official.
Yeah, Section 5E includes this. It's essentially you giving instructions ahead of time to the escrow company.
Right.
You're directing them to pay the broker their earned commission directly from your sale proceeds when the deal closes. It ensures the broker gets paid from the funds held in escrow.
And it mentions interest.
Yes, if that commission isn't paid within, say, 30 days of closing for some reason, it can start accruing interest.
Okay, let's move on to deposits. The earnest money, what role does the broker play there?
Section 6 clarifies that you're authorizing the broker to accept that earnest money deposit from a potential buyer on your behalf.
Okay.
This deposit will then typically be held by either the escrow company handling the sale, sometimes the broker themselves in a trust account, or maybe another party specified in the agreement.
Now let's talk about who's working for whom. Agency relationships. That's Section 7, right?
Correct. Section 7 outlines the agency relationship. It clearly states that the broker is acting as your agent, the seller's agent.
Okay.
The brokerage firm might also assign a specific real estate agent, a licensee within their company, to be your main point of contact and represent your interests.
And what about that situation that can sometimes feel a bit confusing, dual agency?
Ah, yes. Section 7B addresses dual agency. Imagine the same agent, or maybe the same brokerage firm, is trying to represent both you, the seller, and the person wanting to buy your house.
Right. It seems tricky.
It can be. That's dual agency.
Right.
And it requires a specific, separate, written consent to act form signed by everyone involved. Everyone has to agree, fully understanding that the agent's loyalties could potentially be divided.
But what if you have like a big real estate company with lots of different agents, and one agent in that company is working with the buyer, and a completely different agent in the same company is working with you, the seller? Is that also dual agency needing the form?
Ah, good clarification. Section 7C often clears this up. If different agents within the same brokerage are each exclusively representing the buyer and the seller respectively,
Okay.
with each agent fully dedicated only to their client's interests, then that specific situation, sometimes called designated agency, does not typically require that consent to act form. The agents maintain separate duties.
Okay, that's good to know. It makes a difference. Now, as a seller, you have to tell potential buyers certain things about the property, don't you? Disclosures.
Absolutely. Mandatory stuff.
Yeah.
Section 8 lists the required disclosures. First and foremost is the Seller's Real Property Disclosure Statement, or SRPD.
Right.
You're legally obligated here in Nevada to truthfully disclose any known significant problems or conditions with the property, unless you fall under a specific legal exemption. And you need to keep this info up to date if something changes.
What else?
If there have been any past legal claims related to construction defects on the property, those also need to be disclosed according to Nevada law.
Okay.
For any properties built before 1978, there's the Federal Disclosure of Information on Lead-Based Paint Hazards. Very important.
Uh-huh.
And finally, you'll usually acknowledge that you've received the state's Residential Disclosure Guide. The bottom line here is transparency. Failure to disclose known issues can lead to serious legal trouble even after the sale is done.
So those disclosures are mostly about protecting the buyer. What about protecting the broker who's helping you sell? Is there anything like that?
Yes, definitely. That's where indemnification in Section 9 comes in. This is a really important clause for sellers to understand fully.
Okay, what does it mean?
Essentially, you're agreeing to save, defend, and hold broker, GLVAR, and the MLS harmless from any claims, lawsuits, disputes, judgments, basically any trouble.
Right.
That arises from things like you misrepresenting the property, providing incorrect information, maybe failing to disclose known facts, especially hidden problems or latent defects, or issues related to the use of the key box, or even injuries or damages that might occur during showings or marketing activities.
So you're taking responsibility for the information.
Pretty much. You're taking on the responsibility for the accuracy and completeness of the information you provide about the property. And this protection for the broker continues even after the agreement ends and the property is sold.
Wow, that sounds like a pretty broad safety net for the broker. Okay, now, we absolutely can't forget about everyone's right to fair treatment, fair housing. Section 10.
Section 10 explicitly states the broker's legal duty, and yours too, implicitly to offer your property without discriminating against anyone based on a whole list of protected characteristics.
Like race, religion.
Race, religion, color, national origin, disability, sexual orientation, gender identity or expression, ancestry, familial status, meaning having kids or sex, It's aligned with all the federal and state fair housing laws. No exceptions.
Got it. What if the property is part of a community with like an HOA or some other kind of governing body?
Ah, yes. That's covered in Section 11, which deals with common interest communities, or CICs.
Well,
Homeowner associations are the most common example.
okay.
If your property is in a CIC, you're required to disclose that. You need to provide the name of the association, their contact info, the amount and frequency of any dues or assessments, and confirm whether you're current on your payments.
And the documents.
Yes. You also agree to provide the broker with all the necessary CIC documents, the resale package. Essentially, that Nevada law requires to be given to the buyer during the transaction.
Sometimes there are these other unexpected costs tied to a property, like special government assessments for roads or sewers or something.
Right. Section 12 addresses those. Special assessments. These are often from things like a special improvement district, SID,
Right.
or a local improvement district, LID.
Okay.
You need to disclose if the property is subject to any of these assessments and provide details like the outstanding balance, the payment amount, and when it's due. Buyers need to know about these ongoing costs.
Makes sense. Okay, for making it easy for agents to actually show the property, many sellers use a key box. What does the agreement say about that in Section 13?
Section 13 details the key box authorization. First off, you have the choice. You can allow or not allow the broker to install a key box, which could be electronic, or just a mechanical combination lockbox.
Okay.
It explains the purpose, giving access to other MLS members and licensed professionals like appraisers or inspectors for showings and related activities.
And security.
It advises you to secure any valuable items, naturally. It notes that the MLS doesn't actually require a key box be used. If there's a tenant living in the property, their consent is also needed. It might also mention authorizing one-day codes for electronic key boxes, and the broker agrees to take reasonable steps to verify the identity of licensed professionals who get those codes.
And who's responsible if something goes missing?
That's the crucial part. The agreement clearly states that the broker, GLVAR, and the MLS are not insuring against theft, loss, or vandalism related to keybox access.
So it's on the seller's insurance.
Exactly. You need to make sure your homeowner's insurance provides adequate coverage for that potential risk.
Good to know. What if the property is currently being rented out to someone when you decide to sell?
Section 14, rent lease, requires you to disclose if the property is currently occupied by a tenant.
Okay.
You also need to state if there's a property management agreement in place, and if so, with which company. And you agree to give the broker written notice, usually at least 14 days, before you decide to rent or lease the property to someone new during the listing term.
Got it. There's also a section about taxes, specifically for sellers who aren't U.S. residents. That's FRETA, right? Section 15.
Yes, Section 15 deals with FRPITO, the Foreign Investment in Real Property Tax Act. It's a federal thing.
Okay.
If you meet the definition of a foreign person, under FRPITO rules, you agree to fill out a certificate confirming this. And it informs you that if you are a foreign person selling U.S. real estate,
Yeah.
the buyer might be legally required to withhold a certain percentage, often 15%, of the gross sale proceeds. This money is sent to the IRS as a sort of prepayment for any potential U.S. income tax you might owe on the sale.
Oh, wow. Okay. That's significant. What if there's a disagreement between the seller and the broker during the selling process? How are those typically handled?
Section 16 usually outlines mediation. The agreement strongly encourages both you and the broker to first try to resolve any disagreements through good faith negotiation. Just talk it out.
Right.
If that doesn't work, you both generally agree to submit the dispute to a neutral third-party mediator that you both agree on.
And the cost.
The costs of the mediation are typically split equally between you and the broker. Importantly, this section often includes an agreement not to sue the broker directly in court first, and sometimes an agreement not to participate in any class action lawsuits against the broker or related entities. Mediation first.
Okay. Most properties get listed on the multiple listing service, the MLS. What does this agreement say about that in Section 17?
Section 17 covers the multiple listing service. It states that unless you specifically choose the office exclusive option, which we'll get to,
Okay.
the broker will submit all the necessary listing information about your property to the local MLS. Here it's the GLVAR MLS.
And why is that done?
This allows thousands of other real estate agents and brokers who are members of that MLS to see your listing details and potentially bring a buyer. It vastly increases exposure.
Makes sense.
The broker is authorized to cooperate with these other brokers and also to report the details of the sale, like price and terms, to the MLS once it's finalized for comparable data purposes.
Okay. But it says something interesting here. May not include any offer of cooperation and compensation to the buyer broker in the MLS.
Yes, that's a key point in this specific version of the agreement we're looking at. It indicates that the commission offered to a buyer's broker won't be published within the MLS listing itself.
So how does the buyer's agent know if they'll get paid?
That compensation would likely be negotiated and confirmed through other means, perhaps directly between the brokers or as part of the purchase offer itself. It's a shift in how that compensation information is shared publicly via the MLS in this contract.
Interesting. Okay, so if the buyer agent compensation isn't in the MLS, how will potential buyers actually find out about the property then? Through other marketing.
Exactly. Section 18, Marketing and Advertising, addresses this. It generally allows the broker to advertise your property through various channels, online websites, social media, print ads, etc.
But the seller has some control.
Yes. This is usually subject to any specific instructions or opt-outs you might choose later in the agreement, like in Section 20. Unless you sign something specifically saying no photos.
Uh-huh.
The broker can take photos and videos of the property for the MLS and other marketing. If you provide photos, you're giving the broker the rights to use them.
Right.
It also acknowledges that once images are online, well, it's hard to control where they might end up, and that potential buyers might take their own photos or videos during showings.
Okay. And there's a choice here.
Yes. Crucially, you have to explicitly say yes or no. Do you authorize the broker to actually start public marketing and advertising activities?
Okay. What about just putting a simple for sale sign out in front of the property? Is that automatic?
Nope. Section 19, sign, states that you need to give separate authorization for the broker to put up a for sale sign on your property. And putting up a sign is usually tied to whether you've already given the okay for general marketing and advertising back in Section 18.
Got it. Sellers sometimes worry about their property's online presence, like on Zillow or Realtor.com. What control do they have over that?
Section 20, Seller Opt-outs, directly addresses those concerns. You have several choices here about what the MLS can and cannot display online about your listing.
Like what?
Well, you can choose to opt out of having those online comment sections or blogs enabled on your listing display.
Okay.
You can opt out of having automated property value estimates, those Zestimates or similar things, shown alongside your listing, particularly on broker websites.
Mm-hmm.
You can even instruct the MLS not to display your property at all on the general internet, or maybe just not show the property address online.
But does choosing those hurt visibility?
The agreement usually mentions that, yes, choosing these opt-outs could potentially reduce your property's online exposure to buyers. It's a trade-off between privacy control and maximum visibility.
Okay. There's also something called an office exclusive listing. What's the deal with that? Section 21.
Right. Section 21 explains the office exclusive option. If you choose this, you're essentially telling the broker not to widely share your listing information through the MLS network. Keep it more in-house within the listing brokerage.
So it's not on the MLS at all?
Well, the broker is still required to file an office exclusive form with the MLS, sort of registering it.
Yeah.
But the listing details aren't disseminated widely to other brokers through the MLS system.
Okay. But what if they market it publicly anyway?
Here's the critical point. If there is any public marketing of that office exclusive listing, and the agreement gives examples like putting flyers in your window, holding an open house, putting up a yard sign, or doing online marketing,
Yeah.
then the broker must submit the full listing details to the MLS within 1 business day of that public marketing starting. You can't have it both ways. Public marketing requires MLS submission.
So you can't choose office exclusive if you've already said yes to general marketing.
Exactly. The agreement usually states you cannot select the office exclusive option if you've already authorized marketing and advertising back in Section 18.
Makes sense. What about all the content created for the listing? Like the photos the broker takes, the description they write? Who actually owns that stuff?
Section 22, Use of Listing Content, is interesting. It grants the broker a very broad permission to use all the broker listing content.
What does that include?
Photos, virtual tours, descriptions, pricing details, status updates, basically everything related to the listing.
And the permission is broad.
Very. It's typically described as a non-exclusive, irrevocable, worldwide, royalty-free license. That means they can use it, share it, distribute it, even modify it, pretty much however they see fit for real estate purposes. And this right continues even after the listing agreement ends.
Wow. And if I provide my own photos?
You're warranting that you have the legal right to provide that content and grant them the same license. The agreement also usually states that the broker is the exclusive owner of their broker listing content, the stuff they create.
Okay. If there were any legal issues related to this agreement itself, where would they typically be handled? Which states' laws apply?
Section 23, Nevada law, specifies that the laws of the state of Nevada govern this agreement.
Makes sense, given the source.
Right. And any lawsuits concerning the agreement would need to be filed in a Nevada court, specifically in the county where the property is located.
This seems like a very, very thorough document. Is this basically everything, or could there be other agreements floating around?
Section 24, entire contract, addresses that. It confirms that this written agreement contains the complete and final understanding between you and the broker.
So it overrides anything said before.
Exactly. It supersedes any prior discussions, emails, oral agreements, anything. And it can only be changed or amended by a written document signed by everyone involved.
Including an MLS form.
Yes. It often clarifies that an official MLS change order form, if signed by both you and the broker, counts as a valid written amendment or addition to the original agreement.
What if, down the line, some small part of this agreement ends up being legally invalid for some reason? Does the whole thing fall apart then?
Usually not. Section 25, partial invalidity, typically states that if any specific clause or part of the agreement is found to be invalid or unenforceable by a court,
Yeah.
the rest of the agreement will still remain in full force and effect. Only the problematic part gets tossed out.
Okay. What about really unexpected major events like, I don't know, a natural disaster or a pandemic that might make it impossible to actually go through with the sale?
Section 26 often covers force majeure. This addresses those kinds of extreme, uncontrollable events.
Like what?
Acts of God, major acts of terrorism, war, government shutdowns, widespread epidemics, things that make it genuinely illegal, impossible, or completely impractical to fulfill the obligations of the agreement.
So what happens then?
It usually allows either you or the broker to terminate the agreement without being held liable for breach of contract due to that specific force majeure event.
Is there a limit on how much the broker could be held responsible for financially if something goes wrong on their end and the seller suffers damages?
Yes, there often is. Section 27 might include a damages cap. This clause typically limits the broker's maximum financial liability to you, the seller, under this specific agreement.
To what?
Usually it's capped at the total amount of commission that you have actually paid to the broker under this agreement.
Okay. The broker needs to be sure that the person signing this agreement actually owns the property or has the right to sell it, correct?
Absolutely fundamental.
Yes.
Section 28 usually includes a warranty of ownership,
Meaning?
meaning you, as the seller signing the agreement, are formally warranting that you are either the sole legal owner of the property with full rights to sell it, or that you have the proper legal authority, like a power of attorney or trust document, to sign this agreement on behalf of the actual owner.
Makes sense. There's a section specifically about foreclosure. What does that cover? Section 29.
Right. Section 29 requires you, the seller, to disclose upfront if a formal notice of default has already been officially recorded against your property, or if you've been formally served with a foreclosure lawsuit at the time you're listing the property.
And if it happens later?
If a notice of default is recorded after the date you sign this listing agreement, you're obligated to notify the broker in writing, usually within 5 business days.
Can the broker stop it?
No, and the agreement usually includes an acknowledgement where you understand that the broker cannot prevent or stop a foreclosure from proceeding if you're behind on payments. They're a broker, not a miracle worker or a lawyer in that context.
Okay. How do we actually make this agreement official? Does everyone have to sign the exact same piece of paper at the same time?
Not necessarily. Section 30 signatures usually clarifies this. The agreement can be signed in person with good old ink or electronically using secure digital signature platforms. It can even be signed on multiple copies, counterpart signatures, which, when put together, form one complete and legally binding agreement.
What about faxing? Is that still a thing?
Sometimes it's mentioned. The clause might state that signatures sent via fax are considered acceptable as originals for the purpose of binding the agreement, though electronic is far more common now.
Brokers often recommend other service providers during the process, right? Like home inspectors or lenders. What's the seller's responsibility when that happens?
Good point. Section 31 often covers recommendations. It basically advises you, the seller, to do your own homework.
Meaning?
Do your own independent investigation and due diligence on any service providers, lenders, inspectors, stagers, repair people that the broker might suggest or recommend.
So don't just take their word for it.
Well, you acknowledge that the final decision to hire any of these outside professionals is entirely yours. The broker isn't guaranteeing their performance.
Okay. What happens if either the seller or the broker just doesn't follow through on what they agreed to in this document? What's the consequence?
Section 32 usually covers default.
Hmm.
If you, the seller, materially breach the agreement, meaning you break a significant promise or obligation, you could be considered in default. And that might make you liable for the broker's full commission, potentially plus other costs they incurred.
What if the price isn't clear?
If the actual sales price isn't determined because it was an exchange or because of your breach, the agreement often says the original listing price will be used to calculate the fee owed.
And if the broker breaches the agreement,
Conversely, if the broker fails to perform their duties under the agreement, you, the seller, have the right to pursue any legal remedies available to you, which might include terminating the agreement or seeking damages.
who is actually legally bound by this agreement? Just the person who signs it today? Or does it extend beyond that?
Section 33, binding effect, usually states that your obligation, particularly the obligation to pay any earned commission, is not only binding on you personally,
But
also on your legal successors, like your heirs, executors, administrators, and assigns if something happens to you. And Section 34, joint and several, clarifies things if there's more than one seller. If multiple people sign as the seller, like co-owners, each of them is individually responsible for the entire set of obligations, severally liable, and they're also responsible together as a group, jointly liable. The broker can pursue any one or all of them if there's a default.
are the deadlines mentioned throughout this agreement really strict? Or is there some wiggle room?
Generally, very strict. Section 35 usually includes a clause like, time is of the essence of this agreement and each of its terms,
Meaning?
meaning that adhering to the specific timeframes and deadlines outlined in the agreement is absolutely crucial. Missing a deadline can potentially be considered a breach of contract.
Okay. Once an offer on the property is officially accepted by the seller, how does that change the listing status on the MLS? Does the seller have a say?
Yes, they often do. Section 36, sometimes titled MLS Status Upon Acceptance, requires you to choose up front or decide later how the MLS status will be updated once you accept an offer.
What are the usual choices?
The common options are usually under contract show, meaning you'll still allow backup showings just in case the current deal falls through.
Okay.
Under contract no show, meaning stop all further showings. Or sometimes there's an option to simply decide on the status later when an actual offer is accepted.
What if the seller wants to do one of those tax-deferred property exchanges, like a 1031 exchange? Does listing agreement mention that?
It can, yes. Section 37 might be titled 1031 Exchange. It allows you, the seller, to indicate if you intend to perform such an exchange using the proceeds from this sale.
And the broker's role?
If you indicate yes, the broker typically acknowledges this and agrees to cooperate with the requirements of the exchange process, like coordinating with your qualified intermediary. However, you also usually agree to hold the broker harmless for any issues, liabilities, or tax consequences related to the success or failure of your exchange.
Got it. There's often a section at the very end for additional terms. What kind of things might typically go in there? Section 38.
Right. Section 38 provides blank space for any other specific agreements, conditions, or instructions that aren't already covered in the standard printed parts of the contract.
Like what, for example?
It could be anything you and the broker agree on. Maybe specific instructions about showing times, an agreement about the seller providing a credit for specific repairs, details about handling existing tenants, or any other unique conditions relevant to your specific property or situation.
Okay. Finally, there's usually quite a bit of information packed in at the very end about fair housing, sometimes even beyond Section 10.
Yes, the document we reviewed concludes with some pretty comprehensive information reinforcing federal and state fair housing laws.
What does it cover there?
It often reiterates the main laws, Civil Rights Act of 1866, the Fair Housing Act, the ADA, the Equal Credit Opportunity Act. It outlines the responsibilities of sellers, buyers, and real estate professionals in upholding these laws.
And discrimination.
It emphasizes again that any form of discrimination based on those protected characteristics is illegal. It might also address discriminatory covenants sometimes found in old property deeds, noting that they are generally invalid and unenforceable today.
Any resources mentioned?
Yes, it often provides contact information or resources for filing fair housing complaints if someone believes they've experienced discrimination. And it usually highlights the Realtor Code of Ethics and its own strong commitment to fair housing principles.
And then the signatures.
Exactly. Right at the very end, In Section 40, in our example, you'll find the signature blocks for all the sellers and for the broker. And there's often a critical reminder right there. An exclusive brokerage agreement must be signed by the broker to be valid. The broker's signature makes it official.
Anything else down there?
Usually you consent to receive electronic communications like emails or texts related to the transaction, and your agreement to keep your contact information updated with the broker.
Wow. Okay, that was an incredibly thorough breakdown. It's crystal clear now that the exclusive right to sell listing agreement is, well, a really significant and legally binding document. It has major implications for anyone selling their property.
Absolutely. There's a lot in there. Having a solid understanding of all these different provisions it's crucial for a smooth, successful, and hopefully less stressful real estate transactions.
So for you, our listener, I think the most important takeaway is carefully review your own listing agreement. Don't just skim it.
Please don't skim it.
Read it closely,
Mhm.
and don't hesitate, not even for a second, to
Yeah.
ask your real estate professional any questions you have. No question is too small.
Exactly. And maybe here's a final thought for you to really consider, just mull over.
Yeah.
When you think about the truly exclusive nature of this agreement,
How does that actually align with your specific needs and goals as a seller right now? Does giving that one broker the exclusive right offer the focused effort and commitment you're looking for? Or are there any potential downsides or alternative approaches you should maybe be aware of or discuss?
definitely something to think about long and hard before signing. We'll be back soon with more deep dives into the fascinating world of real estate and other topics that matter to you. Thanks so much for tuning in.